Welcome.
Good afternoon, Your Honors, and may it please the Court. My name is Joe White, and I come from the Cumberland County Bar. It's an honor to be here before you, and subject to your approval, I would ask for 5 minutes of the Court's time to use for rebuttal.
Mr. White, of course. Thank you.
Thank you, Your Honor. Your Honors, the appellant in this case, Mr. Davenport, the facts were, and the facts are undisputed here, the facts were that he had assumed that these neighbors had stolen his things, had been selling drugs out of the property. He had called the police. Police action did not address this. Well, he took matters into his own hands. He went to the residence and he, went to the residence, went in to talk to them about it. Now, this first initial interaction with them, he gives them his firearm and they beat him badly. He leaves, comes back the next morning with another firearm. He fires through a wooden door 7 times. He kills 1 person, injures 2. Based on those facts, Your Honors, Mr. Davenport was convicted of attempted voluntary manslaughter, reckless homicide as it relates to the decedent, and then attempted second-degree murder. Your Honors, I am today asking for reversal of the attempted second-degree murder. I am bringing that up from the standpoint of when viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. The essential elements, and that's what I've really gotten into in my brief, because we have 3 different convictions here. We have 3 different mens reas. The jury in their convictions recognize that Mr. Davenport acted under adequate provocation, also recklessly, but in the same criminal episode somehow developed the increased mental intent, mental mens rea to attempt a second-degree murder. And Your Honors, that is completely incompatible with each other. And the case that I have leaned on primarily is State v. Kimbrough, that comes out of volume 924 in the Southwestern 2nd, page 888. And language in that case includes that the relevant case law from other jurisdictions, which they are, looking at other jurisdictions, makes it clear that recklessness and negligence are incompatible with the desire or intention. Earlier in that case, Your Honors, the court, our Tennessee Supreme Court, says that the concept of attempt involves the notion of an intended consequence. An attempt requires a desire or at least an intent to accomplish the consequence. Ultimately, the nature of the attempt requires the specific intent. So, when looking at it, he fires through this door. There's 3 people in there. 1 is killed instantly. That's Mr. Lewis with the reckless homicide. And then the 2 injured parties. So, with these convictions, the jury would have to have found that he somehow was able to split his mental state as it only relates to Corey Hillsman. And Your Honors, there's substantive problems with that because, well, 1, the law has recognized that you can't be reckless and intentional at the same time. And they're saying that he did. And for that reason, Your Honor, I think that, Your Honors, the attempted second-degree murder charge needs to be reversed.
Mr. White, can we address the threshold issue about the timeliness of the appeal?
Yes, Your Honor, absolutely.
And none of this is of your doing, and we understand that, and we're not talking about that at all, but it does look like there is a delay of, give or take, about 250 days between the time when the notice of appeal should have been filed if it were timely and the time where it was actually filed otherwise. And as I understand, the rationale or the reason is that the parties may have thought that there was a motion for a new trial that had been filed that would toll the running of the deadline to file the notice of appeal, and that the absence of the motion for a new trial was something that came to light only later, and that once it did, quick action was taken.
Yes, Your Honor.
What I don't see in the record, though, is anything that would have prevented the motion for a new trial from actually being filed within the 30 days. And I'm curious about how you would distinguish Manning. Are you familiar with Manning?
I'm not familiar with the case, Your Honor, and I apologize.
Well, Manning, no, and there's no reason necessarily in particular that you should be. It's an unreported case from this court, but I wonder if superficially the circumstances may be a bit more compelling, though not much availing. My recollection of the facts in Manning were that the defense counsel had the 30-day deadline for the motion for a new trial to be filed and could not get the motion filed in time. So counsel at that point requested from the trial judge an order extending the time by which to file the motion for a new trial. Trial judge granted the motion, said you have an extended time. Trial judge had no authority to grant that motion. Black letter law going back a long way that can't, trial judge has no authority to extend that motion under the rules of criminal procedure. Consequently, because the motion for new trial was filed late, of course the notice of appeal was filed late. And it comes to this court, and this court said, I believe it said, held in Manning, that you may have intended, tried to do all the right things to get a timely motion for a new trial filed, you didn't. And it didn't matter that the state agreed to it, didn't matter that the trial court issued the order, there was no authority for that to happen. We find no good cause to waive the requirement of a timely filing. The reason I think those circumstances may be a bit more compelling here is because counsel in Manning attempted to show why the motion for new trial was filed late, why it couldn't be filed within the 30 days. And in this case, there's no proof, once again, not your issue, but there's no proof in the record to show why predecessor counsel could not have filed the motion for a new trial timely.
Yes, Your Honor.
Or why one was not filed. And in the absence of anything in the record explaining that, it seems difficult then to reach any conclusion that a waiver of the timely notice of appeal should be excused in the interest of justice. Because all we have is just a blank record without any fact to weigh about whether it would be in the interest of justice to excuse it. And so I'm not even really focused on the delay that occurred afterwards. For me, it's why could not the motion for a new trial have been filed within the original 30 days? And so without anything in the record to support that, what's the argument here that the interest of justice would compel a waiver of the timely filing requirement?
Yes, Your Honor, and I think it would...
and how do you distinguish Manning?
Well, I would distinguish Manning in that, in Manning it seems that there was a clear issue with the untimeliness. In this case, it appears that the court and the counsel all thought that the motion for new trial, or at least the placeholder motion for new trial, was in place.
How do we know that?
Well, it was never brought up. So
that's what I'm saying. So, I mean, you're asking me to draw an inference from a silent record, and I wonder if we can. For example, and I'm not suggesting this is the case, I'm just suggesting possibilities. It could be that there was never an intention to file a motion for a new trial. It could be. It could be that there was just extreme recklessness, that maybe I thought the time ran on this date, it didn't. It could be simple negligence. It could be, I instructed my staff to have the motion filed. I didn't follow up on it as I should have. It's my case. And it just didn't get filed timely, didn't get filed at all. There could be a lot of reasons. And so you're asking the court to make an inference on one side of the scale, but there are, if I'm drawing inferences from a silent record, I could draw inferences on the other side of the scale as well.
Yes, Your Honor. And out of those options, I would pick negligence. And I was second chair in this trial. I'm willing to follow my own sword on that. I had filed a amended motion for new trial because I was under the impression that it was in place. And I know that the record doesn't speak to that. However, the court had never made an issue about it. The DA had never made an issue about it. I thought in my short 3 years of practice, this is how it works. So when I was appointed appellate counsel, I had no reason, or I had no belief that it wasn't orally made. And that's what I thought. And that's what the primary counsel thought. It was that, hey, this was made. And I looked at the record. It's not on there. The oral motion is not on there, and that is conceded.
Even if you make, I'm sorry. No, go ahead.
We're going to say the same thing.
Okay, all right, go ahead.
It has to be in writing, though,
Yeah.
right?
I mean, even if you
Yes.
orally make it, you have to file the written motion within 30 days.
Yes, Your Honor.
Okay.
And with that, of course, the next time I'm in front of you, it will be in writing. And I know that given the facts what they are, I still go back to this man relied on his attorneys. This man relied on his attorneys to get that filed. He would have not have known. He wasn't appointed appellate counsel until much later in the case. And at that point, everything was submitted timely because, again, I was operating under the belief that that placeholder motion for new trial was there when it wasn't.
But even in Manning, though, the client in Manning, Mr. Manning, I suppose, relied upon his counsel, and his counsel relied upon an order from the trial court.
Yes, Your Honor.
And still at this point, the court in that case, and I can't remember the delay in that case, but my hazy recollection is a little over 70 days maybe, still found that a waiver was not appropriate in that circumstance, given the clear law to the contrary.
And, Your Honor, the delay in this comes from a very large, voluminous transcript. There's no doubt about that. It took a while to get the transcript. It took a while to get everything in place before we could even argue the motion for new trial. Certain delays were there just from the nature of a 3-day murder trial. And again, I just think in the interest of justice, I'm asking the court, I'm begging the court to please see it in the interest of justice because I don't think anything was intentional, and I don't think the delay was gross negligence. I don't think it was complete recklessness from trial counsel, which I was second chair. So it was largely a misunderstanding here, and I understand the state's position on this, but with that, I still ask and I still implore the court to find in the interest of justice that that time should have been waived, especially considering that was the only wait time issue. I mean, the brief was filed on time. The brief was responded to when the appellee issued their brief. All of these things, Your Honors, I think should indicate and lead towards the interest of justice requiring that it do be waived.
One of the issues that the court will sometimes consider in waiving a untimely notice of appeal or the requirement of a timely filing are the nature of the issues that are raised. What I understand you're raising is essentially a challenge to an inconsistent verdict. And I think in Davis, the Supreme Court said we evaluate each conviction on its own merits. And so in this case, under the attempted second-degree murder, we evaluate the proof that would support that conviction without reference to any possible inconsistency arising from a different verdict. And so it looks like Davis may be inconsistent with the argument you're raising, that the jury could not possibly have reached two separate conclusions here. I think Davis puts an end to that argument. What's your view of Davis?
Well, and I am unfamiliar with Davis. I think recklessness on its own, and I'm not sure if Davis included the attempted voluntary manslaughter, but the provocation, recognizing that he was adequately provoked. Well, are we going to say that someone who is adequately provoked to commit such acts can also be intentional at the same time?
I think Davis was just more of a, and obviously the Supreme Court will speak for itself. I think Davis was simply concerned that we can't know why a jury reached an inconsistent verdict. It could be because it had differing views of the proof, as you're arguing, that maybe are fundamentally inconsistent. It also could be simply that the jury decided to take mercy on the defendant on a particular charge. Juries do that. And so because there may be different reasons why a jury could reach a superficially inconsistent verdict from our perspective, but we wouldn't go back behind that to start vacating convictions based upon our perception of an inconsistency.
Yes, Your Honor.
So if Davis says that in less words than I did, it seems to me like the argument doesn't hold very well, or I wonder if it does.
Well, and I wonder the same. However, that language in there, that recklessness and negligence are incompatible with the desire or intention. I still submit that how could he have had the certain desire to only have killed one person in that house, especially through a wooden door where he can't see anything in there? He's not specifically aiming at Mr. Hillsman. He's not trying to shoot Mr. Hillsman and then they're in the background. The facts show that he knew who was in there. So for those reasons, Your Honor, I know that juries can come up with what I would call a compromise verdict. However, when it's completely different mens rea-wise, I think that the only logical thing, or the only logical answer to that, is to reverse the heightened standard when they recognize that he wasn't operating under a specific mens rea.
Okay.
Thank you, Your Honors.
Mr. Wyatt, thank you very much. Thank you. General, good afternoon to you.
Good afternoon, Your Honors. May it please the court. Garrett Ward on behalf of the state. Your Honors, this court must uphold the verdicts against Mr. Davenport for reckless homicide, attempted second-degree murder, and attempted voluntary manslaughter because the evidence is sufficient to support these convictions. There's a sentencing issue in this case. Unless this court has questions on it, I'll rely on my brief for sentencing. Before I talk about sufficiency, given the court's interest in the issue, and my friend on the other side spending time on it, I'd like to at least briefly discuss timeliness. It's the state's position here. I think our notice of appeal is about 250 days late, and I've got a great degree of sympathy for my friend on the other side here, because I think that ultimately the delay here is not down to him. This delay in filing the notice of appeal is largely down to confusion about whether or not there was a timely filed motion for new trial.
How do we know that? And the reason I ask that is that there's no affidavit in the record.
So I take that, I make that statement, Your Honors, based on two things. One is the motion for new trial we do have filed. It's untimely. It's styled as an attempted motion. So it certainly seems like there was maybe some belief based on styling it as an attempted or an amended, that there was an initial motion for new trial filed. And then in Mr. Davenport's reply brief, he indicates that my friend on the other side indicates that he believed there was a placeholder motion filed.
So typically, it may be in response to the state raising the issue. Typically, there would be an affidavit. Typically, there would be some proof in the record, and not just, hey, look, I mean, the court takes things on faith all the time. Mm-hmm. I think in this case, though, not just in this case, but in these types of issues, I think there has to be something in the record to show why the motion wasn't filed within the first 30 days.
If nothing else, Your Honor, that's best practice, because otherwise an appellant leaves himself open to the exact problem that Your Honor is noting right now, that this court doesn't really have a good grasp on why there was a delay. And the reason for the delay is one of the factors under Rockwell that this court looks to evaluate whether or not the interests of justice are in favor of waiver.
And in fact, it may be the most important, because a long delay can be excused if there's a good reason. A short delay, a one-day delay, we have held is not excused in the absence of a good reason. Mm-hmm. And so that reason may be the most important. Rockwell itself says that if we were to excuse untimely notices of appeal in every case, the requirement of a timely filed notice of appeal would serve no purpose and have no meaning. Mm-hmm. And so this court will excuse notices of appeal, late notices of appeal, where there has been a showing of a reason. Excusable neglect, for example, genuine confusion over procedural requirements, if that's possible, as it goes. On a record where there is no reason stated and we're really left to speculate, I wonder if the interest of justice could ever be served by waiving the notice of appeal. And the requirement of a timely notice of appeal.
Your Honors, I'll leave that ultimate determination up to the discretion of the court. It was certainly, the state would say it's certainly advisable to provide these sort of affidavits, because otherwise you are, as Your Honor said, asking the court to take it on faith. And for a 250-day delay, perhaps that's a little bit too much.
Okay, Your Honor, sorry. Yeah.
But turning, I guess, to the other Rockwell factor, or the named Rockwell factor, there's sort of a nebulous catch-all in Rockwell. Rockwell does suggest that court should look to the nature of the issues. So both to address the merits of the sufficiency argument and to sort of buttress the state's position that I don't think the interests of justice are in favor of waiver here.
There's at least one case I'm aware of where there is a split on a panel about whether that's a genuine Rockwell factor and how much it should be given weight. I addressed it with your friend on the other side in fairness to his argument and wanting to explore Davis a bit as it goes. There's at least a split on the court maybe about whether that Rockwell factor, about the nature of the issues, is really doing a lot of work, though.
I understand that, Your Honor. I take this largely, funnily enough, from the Manning case that you discussed with my friend on the other side. Manning treated the nature of the issues as at least
As a factor.
as a factor under Rockwell. But whether I'm discussing the sufficiency and as part of a nature of the issues Rockwell analysis or just because it's the issue my friend spent time with, I think it's important to discuss the sufficiency challenge at least a little bit, or with the remainder of my time. And Your Honors, to the extent that the nature of the issues exists as a factor under Rockwell, it doesn't work in the defendant's favor here, because the nature of the issues are rather foreclosed by black-letter Tennessee law. Like yourself, Judge Greenholz, I found the sufficiency problem here to largely be one of a complaint about inconsistent verdicts. And if there's one thing my friend on the other side and I agree on, it's that the jury's verdict here is inconsistent. It's perhaps a little confusing. But what I believe it's the Wiggins case cited in my brief from the Tennessee Supreme Court from '73 essentially says juries are allowed to be confusing in their verdicts and we don't look behind that door. And then the Davis case that Your Honor mentioned earlier says the only thing we look to is we look to each count on their own, we don't weigh it for consistency with other counts in an indictment, and we look at the sufficiency of the evidence.
General, if you don't mind me interrupting you.
Certainly, Your Honor.
Looking at each count on its own, and I don't think this is an issue that has been raised in this case, but I'm new and I can ask questions that are irrelevant.
And I'm happy to
with
answer
the best
them.
of them. So I'm curious, the jury's finding as to Florence Easterly, where they found that count attempted voluntary manslaughter, and I was looking through the record and said, well, what did she do that was provocative? Because my understanding is that Mr. Lewis had the sword, and Mr. Hillsman was the one that was actually having this confrontation at the door with Mr. Davenport, and I was thinking, well, what did she do? Is there evidence to support that conviction for attempted voluntary manslaughter?
So a couple points on that, Your Honor. One, as you noted, that complaint hasn't been raised. I'm happy to answer Your Honor's question, though.
I don't mean to waste your time on it. It's just an intellectually curious question.
Answering questions that are based on intellectual curiosity is certainly not a waste of my time. It's one of the more enjoyable parts of my job. I think as we're looking to adequate provocation here, I think the jury is and obviously we don't know. The state didn't seek a voluntary manslaughter conviction, so there's not a clear theory from the state on adequate provocation. So sort of peering into the mind of the jury, which is a dangerous proposition and one I believe I've just told the court, the Tennessee Supreme Court says that I shouldn't do, but nonetheless doing it at least briefly, I think the jury's probably looking to two things. One is this belief that Mr. Davenport had that perhaps his neighbors had been stealing from him. I certainly would stringently advocate that that's not adequate provocation, but perhaps a jury could view it in that way. There's also testimony about, I believe it's Mr. Lewis is the one that is wielding the sword in this case, Judge, but perhaps the jury could have generally looked to the introduction of the sword here as perhaps adding some degree of adequate provocation. I'm really speculating as to what the jury may have done, but those would be the two things I would point to. He has this belief that he's been stolen from, and then there is this sort of introduction of this sword. That perhaps the jury looked to that and said, well, maybe that's adequate provocation, but I think realistically the jury's probably cutting him a break here. But, you know, and I think that's the lesson for litigants in Tennessee and courts is that we really don't look to, we have an inconsistent verdict here, absolutely, and that's simply not a problem. If I may speak briefly to Kimbrough, which is the case that my friend on the other side is relying on to make a lot of his argument. I think there's maybe a bit of a lack of clarity on what Kimbrough is about. That is contributing perhaps to my friend's argument that Kimbrough somehow prevents this kind of verdict. But Kimbrough isn't an inconsistent verdict case, as this court is well aware. Kimbrough is a pretty seminal case from the Tennessee Supreme Court, says attempted felony murder is not a crime. And it's in that context that the Tennessee Supreme Court says there's inconsistency between intent and recklessness and negligence, with the idea being that felony murder can be, at least as to the killing, can be committed with a negligent or reckless mindset, and that is inconsistent with the intent mindset that is required for the crime of criminal attempt. So in that case, the Tennessee Supreme Court has essentially said, okay, we're not going to, those things are inconsistent. We're not going to allow attempted felony murder. I don't think that Kimbrough really has any part to play or really does anything to mitigate the clear holdings of Wiggins and Davis. Gardner is a case from this court on inconsistent verdicts. There's a bevy of cases on inconsistent verdicts, and all of them say the same thing, that it's not something that Tennessee courts are concerned about. We just look to, is the evidence sufficient on its own? Kimbrough doesn't undermine that. And obviously, Kimbrough does nothing to undermine the sort of existence of the crimes of attempted second-degree murder and attempted voluntary manslaughter, as I've discussed in my brief. Given that all we are concerned about in these sorts of cases is the evidence for the crimes of conviction sufficient on their own, I think the answer there is a clear yes. That when a person knows there are people on the other side of a door when he's trying to force it open against the efforts of the homeowners to keep him out, then he steps back and opens fire through that door with a high-powered rifle, with the shots being clustered at the doorknob, that he's taking a course of action that is reasonably certain to cause the death of the people on the other side. Your Honor, frankly, it's fortunate for Mr. Davenport that there's only one death here, or he'd be looking potentially at much more time than he's currently serving. The evidence is easily sufficient for both of the attempted homicide cases in this case. Unless this court has further questions, I'd ask that you affirm.
General, thank you very much.
Thank you, Your Honors.
Mr. White, you have 5 minutes in rebuttal.
Thank you, Your Honor. And the sentencing aspect of this, I know that that General Ward has decided to rest on the brief, but I would like to bring that up because Mr. Davenport, he had one previous aggravated assault, and then he has these charges, and then the judge nonetheless found it to be in the court's interest and its decision to stack those charges and sentence him consecutively. And, Your Honor, pursuant to Tennessee Code Annotated Section 4035-115A, the court would have had to have found that Mr. Davenport was a dangerous offender whose behavior indicates little or no regard to human life. I understand the situation. I understand that people were injured and one person was killed in this case. However, in Gray v. State, and that's 538 in the Southwestern 2nd, the decision to impose consecutive sentences when inherently dangerous crimes are involved should be based upon the presence of aggravating circumstances and not merely on the fact that 2 or more crimes were committed. Yes, there are 3 what could certainly be classified as violent crimes here. However, when looking at Mr. Davenport's past, he is not a dangerous offender who has indicated little, or let me back up just a little bit. He's not someone who's committed himself to a life of crime, which is also one of the elements there. And he takes large exception to being labeled as a dangerous offender who indicates little or no regard for human life. And the case law is very clear. The court should have found through the Wilkerson factors and through the statute that I referenced that he is such a dangerous offender. And
Did the trial court make the Wilkerson findings?
It did, Your Honor, but it seemed conclusory as it related to that, whether he's a dangerous offender. They basically said he's a dangerous offender because look at his violent crimes, and then kind of went on from there. However, Your Honor, I think that's erroneous, and for that reason, I would ask that the court reverse the decision of the trial court based on improper consecutive sentencing. I would cede the rest of my time, Your Honors. If there are any questions, I'd be glad to answer.
Mr. White, thank you very much.
Thank you, Your Honors.
We appreciate both of you traveling, in particular, to be here today for us. Thank you. The briefs and the argument were excellent, so thank you both very much for your argument. Yeah, thank you. Will you call the next case, please?